Let's go to our panel now. Jason Bosland is the co-director of the Centre for Media and Communications Law at Melbourne Law School. And in Sydney is TV producer and investigative journalist Kate Doak. Thanks for joining us, both of you. Kate, let me start with you. So, looking at it from the outside, is this a case of a free press versus draconian laws? Or is it maybe just the fact that the suppression order was valid, was relevant, the journalist violated the gag order and they have to face the consequences? Which one's closer to the truth?
I think it's a mixture of all of them because with any free society, we need a legal system which can give people a free and fair trial, no matter what. And I think that given the publicity surrounding the Cardinal Pell case, that in order for that free trial and fair trial, most importantly, to occur, that we needed to have a stable situation where the jury wasn't prejudiced against the either the victims or the perpetrator himself.
Right. Okay.
And
So, right. Sorry to interrupt you, Kate. Right. But in this day and age, with Twitter and the nature of social media, and the fact that even if some of these journalists who are alleged to have passed on information to the New York Times, even if they didn't do that, right, the information would have gotten out in this day and age. It's highly unlikely that it could have stayed contained. So I guess the question is, how do you control all of this in this day and age, Kate?
I don't think that you really can in some cases. However, I think that it's important we try no matter what in order to ensure that like a free and fair trial occurs. Now, in this particular case, Cardinal Pell is an extremely prominent figure here in Australia, both politically and socially. And as with everybody else, he deserves to have had a fair trial. And if we can't give him that, what can we give anybody? How can we say to anybody, whether they be a victim or a perpetrator or anyone in society, if we cannot give that fairness to you, what else can we give?
Okay, so Jason, the argument being that violating a gag order from the media when it came to the Pell trial and the accusations that were further in the separate case might have hindered the man being given a fair trial and the two further alleged victims from receiving justice. Your response to that is what?
Well, that's right. I mean, granting suppression orders in these types of cases where you have back-to-back trials are not uncommon. They're not uncommon in Australia, and they're certainly not uncommon in other jurisdictions either. So this case isn't an unusual case in that respect. What is unusual about it is the fact that it involves someone who was a high-profile figure. It involves someone who was being charged with offences which were, I suppose, there's a lot of international attention around those, particularly because of the history of the sexual abuse in the Catholic Church, and so I think that the certain circumstances around this case meant that it became unusual. But I certainly think suppression orders, in and of themselves, when you have back-to-back trials, are not uncommon. Certainly they've been made in England, for example. They're made in other jurisdictions, and they're made in most jurisdictions in Australia. Not so much in New South Wales, actually. New South Wales is probably the one jurisdiction in Australia where there haven't been, historically, these types of orders made in back-to-back trials, but Victoria certainly, and in other jurisdictions as well.
Okay, so Kate, an argument being that when it comes to the Catholic Church, it's an international institution. It's a story that has captured the international imagination. It's not a local Victoria story. And of course, the allegations, which Pell was later convicted for, involved crimes of a heinous nature, right? With all of that in mind, reporting on it in defiance of a gag order is in the public interest because the public needs to know. What do you think?
I think it is in the public interest. However, with a story of that particular nature, it will eventually be reported one way or another. And if it means that we've got to take a few extra steps in order to ensure that like a second trial isn't prejudiced, and that the people who are making the allegations for a second trial or within a second trial, if they're able to be able to put their particular case forward, I think that there's a justifiable reason for us to delay our reporting. That doesn't necessarily stop us from preparing the reports, from doing further in-depth research of our own, which we can then utilize at a later date once the suppression orders have been lifted in any such case. However, I think that in the interest of justice and also in the interest of being accurate, we have got to be very wary of anything we do as journalists whenever there's a media suppression order on a case involving sexual abuse of any form, whether it be a rape case against an adult or sexual abuse towards a minor. I think that we've got to treat these cases and stories with the utmost respect, because we owe that not just to the victims, but to our audiences as well. Because what would have happened if Cardinal Pell had his entire case reported on from the start, and then everything fell apart? Like, we've got to be fair to him as well in regards to this.
Right. Well, was it the right thing? Sorry, Kate, sorry to interrupt you. Right. Was it the right thing, Jason, for those journalists to feed the info to the New York Times and the Washington Post? Okay, we can't report on it in Australia, but take this info. Yeah, take this little WhatsApp message.
I'm not sure whether or not that's exactly what happened, to be honest. I think the circumstances as they stand are that we don't know how the Washington Post came to learn about the conviction. I'm not sure whether or not there were local journalists who fed that information to those news sources. There were certainly journalists from the New York Times in the court who were reporting on the case, and they didn't breach the suppression order. So the exact circumstances around, for example, the Washington Post or the Daily Beast coming into possession of information about the trial, I think is yet to be determined. So I think we can't really comment on that. But I wouldn't mind just commenting really on other aspects of the order that I think need to be emphasised. And one of those is that the mainstream media in Australia had every opportunity to challenge the order at the point that it was made. And in fact, under the Open Courts Act, as it operates in Australia, in Victoria, they are required to receive 3 business days' notice of any application for a suppression order, and they chose not to challenge it. And the media sources that I spoke to had said to me, and I spoke to a number, that this order was a perfectly justified order, and if there was ever going to be a case where a suppression order was justified, this is the one.
Right.
So it's odd that then when the verdict is actually announced and the local media can't report on it, that all of a sudden they're making claims about being censored.
Right.
And I think it's a bit hard to swallow, actually.
Okay.
Now,
So,
I'm not a pro-suppression order person. I am someone who thinks that suppression orders should be used in very rare circumstances. At the same time, I think there is a real inconsistency there between the approach of the media when the order was actually made and the approach of the media when the verdict was handed down.
Okay, Jason and Kate, it's been good to talk to both of you. Thank you very much for joining us here on the Newsmakers.